Welcome to Synergy's monthly Insight webinar series. This webinar is part of an ongoing series featuring one of Synergy's subject matter experts giving you thought leadership insights into issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says questions. If we don't have time for a live Q&A today, a Synergy subject matter expert will contact you to provide answers to your questions. Before starting today's webinar, the following is a brief presentation giving you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Thank you for joining us today. This webinar is about Medicaid, military, and hospital recovery rights. This is really a part two. I previously did a similarly situated webinar focused on ERISA, FEHBA, traditional Medicare, and Medicare Advantage. Those are the major lien types that Synergy handles for lien resolution.
So I am Teresa Kenyon. I am the Director of Lien Resolution here at Synergy. I am a licensed attorney in both California and Kentucky. And prior to joining Synergy 4 years ago, I worked for the Rawlings Company for almost 8 years, representing those health insurance companies that are taking dollars from injured party settlements. So happily, I am now on the better side, and I've got a whole team of subject matter experts that know all about how to handle that other side because they've come from the other side, and they've got tips and tricks up their sleeve, and they passionately want to fight for the injured party and save them their settlement funds.
All right, so first up, we are going to talk about Medicaid. So just to talk about the basics, Medicaid is a public benefit program that provides health benefits to lots of Americans. These are mostly low-income adults, children, pregnant women, elderly adults, people with disabilities, essentially people who really need the health care from the government. This program is funded by both state and federal funds, but it is administered at the state level. So each state kind of has their own way of handling these Medicaid liens. And when Medicaid makes a payment for medical expenses, they have a lien against that beneficiary settlement under their state's Medicaid recovery laws. Federal law plays into this as well, and we'll talk about that here going forward. But federal law allows the states to have the statutes that they then get to follow with some restrictions and exceptions. The first pivotal case regarding Medicaid reimbursement came in 2006 in the Ahlborn case. And in this case, the U.S. Supreme Court limited the amount of funds that Medicare could recover when a beneficiary receives any kind of settlement in a third-party liability case. Under federal law, Medicaid was entitled to only recover funds that were attributable to medical expenses and not the entire settlement. It was stated that state statutes that mandated full reimbursement were unenforceable if they didn't exempt the recovery from non-medical portions of the settlement, like pain and suffering and lost wages and other things that were not medical expenses. So essentially, the Ahlborn court said that state third-party liability provisions are unenforceable if they have a different conclusion than what the Ahlborn case said. So let's talk briefly about the Ahlborn calculation, or the formula that came from the Ahlborn case. Essentially, in this calculation, you determine the reimbursement by taking the total settlement that you were able to obtain for the Medicaid beneficiary. You then divide it by the full value of the claim, had you not been limited by policy limits. And then you multiply that number by the lien that Medicaid is asserting. So here we've got just a couple numbers to demonstrate. So let's assume that it's a $100,000 settlement and that the lien amount asserted by Medicaid is $50,000. So we'll start with that $100,000 and we will divide it into the $800,000 value of this particular claim. And of course, these are all made up numbers, but that is essentially a 0.125 percentage. So then you multiply that number by the amount of the Medicaid lien, and then you are left with the Ahlborn reimbursement amount, which in this case, that $50,000 lien is reduced to $6,250. And this was certainly an accepted calculation for a good number of years before it became a little bit more of a gray spot. So the next pivotal case was in 2013 with the Wos case. This is where the U.S. Supreme Court affirmed the Ahlborn decision from 2006, and they reviewed the North Carolina Medicaid recovery statute. And this North Carolina statute allocated 1/3 of the settlement to medical expenses. Whether it truly was 1/3 or it wasn't, this was the stated number and percentage that North Carolina Medicaid was going to use. Ultimately, the U.S. Supreme Court decided that these kind of arbitrary allocations in these state statutes were not enforceable, and the Medicaid anti-lien rule in Ahlborn thereby prevented this North Carolina statute from being enforced. The most recent pivotal case is the Gallardo case from 2022, and this is where the U.S. Supreme Court took a look at the Florida Medicaid recovery statute. And in this case, the U.S. Supreme Court said that reimbursement can come from any payment of medical care. And that is whether it is past medical care or future Medicare, which is a shift from the prior court decisions. So ultimately, this decision is going to have more serious implications on certain cases. And so each case is going to need to be looked at on a case-by-case basis to see if the Ahlborn analysis still applies or if it's now modified because of Gallardo including future care. So in cases where there is no future care, then the Gallardo case isn't really that impactful. But in those situations where there is going to be a lot of future care or the settlement itself is mostly due to future care, this is going to change the calculation. Now, very recently, as recent as March 8th of 2023, there was a letter that went to all state Medicaid agencies from the Department of Health and Human Services, and the letter was titled Third-Party Liability in Medicaid, State Compliance with Changes Required in Law and Court Rulings. And essentially this letter is advising the state agencies of things they should probably already know, but nonetheless it's considered guidance, and they were advising of two new third-party liability requirements. The first one was just regarding the requirement that states have laws that bar a third-party payer from denying payment based on the fact that there wasn't prior authorization. It can't then fall to Medicaid. But the most important thing as it relates to lien resolution is that it advised more specifically about the Gallardo case and what that means for these states that are recovering based on their Medicaid statutes. So on the left here is the cutout from the actual letter that was sent to all these Medicaid agencies, but essentially, just as we already discussed, it was reiterating and affirming to all the state agencies that the U.S. Supreme Court held that a Medicaid program can seek reimbursement from a settlement even if it's got past and future medical expenses, that it is now expanded and that Medicaid agency can now recover more, essentially. So let's switch from Medicaid and turn to military liens. So military liens include all of the branches of the U.S. military. We've got some emblems here. So we've got the Army, and the Marines and the Navy, the Air Force, the Space Force, the Coast Guard, and the Department of Defense National Guard. So these military liens come from two main sources, TRICARE and VA, and this is just essentially the health insurance coverage under the Veterans Administration, CHAMP VA, and TRICARE, and they all have recovery rights under the Federal Medical Care Recovery Act, or the FMCRA, and there are other provisions of federal law that kind of feed into this. So let's first talk about the Federal Medical Care Recovery Act. The site is listed down below here on this slide, but essentially this particular act provides for the recovery of the cost of medical care that is provided by the United States to anybody who has a disease or injury that has been caused by negligence of somebody else. And so for TRICARE beneficiaries, this includes care that has been received at a VA facility or under their TRICARE insurance or both. So this particular act applies to illness or injury, including work-related injuries that are caused by a third party, intentionally or negligently, meaning unintentionally, for any kind of injuries that are caused by that third party's failure to act when they otherwise should have acted. So the act here itself kind of spells this out in a number of different ways, but it's all saying the same thing. So just an example is when a beneficiary is in an auto accident, it was caused by somebody else, they receive medical care that is paid for by their TRICARE insurance, and under this act, it allows the government to recover the amounts that have been paid from the negligent party. So with that, it's actually important to note and to challenge that there isn't really a military lien against the settlement that has been received by the beneficiary. And instead, this particular act allows for a direct cause of action by the government against the third party. Now, as claims are being processed by TRICARE and they see that there are claims that appear like they could be third-party liability related, they will send out this statement of personal injury, possible third-party liability form, and this is form 2527. If you've ever had a client that has military liens, you've no doubt seen this on the front end. So in these cases, the beneficiary must complete and return this form within 35 days, or they will begin denying payment of claims, which can then just cause a bigger mess with providers not being paid for the services they've provided. I fully acknowledge that this is not completely readable on this particular slide, but just wanted to show a screenshot here of what the form looks like. It's pretty simple, it's pretty basic, but this is the content of the form. Now, the government's usual response to receiving this form is to then send a form letter themselves advising of their authority and providing an agreement to protect the government's interest form. And this is essentially asking the beneficiary's attorney to agree to a number of things. And they cite a couple different statutes or where their authority comes from, but they advise that they are prohibited from paying a fee for any kind of collection of the government's claim. And they advise that the government has an independent cause of action against the settlement, and that any kind of contingency fee that beneficiary might have with their attorney doesn't apply to them. So they don't have to reduce for attorney fees off of their asserted lien amount. And they also say that in return for assistance, so for the beneficiary's attorney to assist them in being reimbursed, they will in turn assist by providing medical records, and they will also provide access to locally available medical officers who have treated or can treat the injured party, and that would be without cost. So this is an odd kind of horse trade of sorts, where they are promising medical records and doctors in return for the beneficiary's attorney to represent them and give them settlement dollars that otherwise would have gone directly to the injured party. So on the left-hand side here, I've got just a snip of the agreement, the attorney protection agreement, and really just taking a step back, it's very apparent that there's a conflict of interest by signing this agreement. If an attorney who is representing a military beneficiary signs this, they now are agreeing not only to represent their client, the injured party, but they've also agreed to represent the government. And these two parties are now looking at what is usually a very specific and limited settlement fund. Synergy usually recommends that these are not signed. However, sometimes it is to the point where it must be signed in order for claims to be paid. So as it relates to completing the initial form that we talked about or signing the attorney protection agreement, we are often asked, what is the obligation of the beneficiary? And there is a specific statute that draws attention to what the beneficiary should do. And so essentially, it is worded that in order to ensure expeditious and efficient processing of claims, that anybody who receives that treatment under TRICARE or their personal representative or counsel is required to provide information about the coverage from a third party and to provide information about the injury and the circumstances surrounding it, to provide any additional information that may be requested, and to cooperate in the prosecution of any claims by the U.S. against the third person. So it's not specifically saying that forms have to be completed or agreements have to be signed, but it is essentially providing that there is an obligation for the beneficiary to cooperate and to otherwise protect the interest of the government. Now, before we move on to the final lien type that we're going to discuss here in this webinar, I just wanted to draw attention to what is essentially a made whole provision as it relates to any government plan. And the citation is down below there, but essentially it states that no action taken by the United States in connection with the rights afforded under legislation shall operate to deny an injured person recovery for the portion of their damages that are not covered under some other statute. So this is sometimes useful and accepted as the hardship, as the made whole piece for getting these government liens reduced. Okay, so let's move away from those government liens of Medicaid and military and now turn to hospital and provider liens. Now, these hospital and provider liens are a beast of their own. They are definitely standalone from the health insurance, health benefit kind of liens that we've talked about all the way up until this point. Most states have statutes surrounding the ability of a hospital to assert a lien. Some of these liens are created at the county level, and then others are created contractually. So that's when they are providing treatment to the patient, they get a written contract, a written agreement that that patient will pay them back at the time of settlement. So really, as it relates to these hospital liens, it's certainly not federal. It's not that there's a one size fits all. 40 states and DC have state hospital lien statutes. Florida, for example, has 9 counties that have valid liens by ordinance. Meanwhile, there are 9 states, and they are listed there, that don't have a hospital lien statute at all. And As previously stated, many hospitals will just create a contractual lien upon admission. So again, hospital liens are different than the normal health insurance lien situation. And that is mostly because there's a difference between liens and debts. So a lien attaches to the settlement funds, and those liens can only be created by statute or contract. Meanwhile, a debt attaches to the person. So medical providers can always assert a debt, but they don't always have a lien right. And it might be that you negotiate away the lien that is against the settlement funds, but then they still maintain the debt. So when you are approaching these, you have to look at both, and your ethical duty is more related to the lien, not the debt. And ultimately, whether that debt is handled is up to your client, to the injured party. If they don't pay the debt, they could have it go against their credit, and there could be other negative impacts. But ultimately, if there is not a lien, then it is not attached to the settlement itself. So just an important distinction. So I want to highlight some limitations regarding this lien versus debt difference. So if a third-party facility, if a hospital or provider has a statutory lien, then that statute usually limits the lien to reasonable charges. On the other hand, if that third-party facility or provider has a debt and they are just like any other creditor, then the common law usually limits that debt to the reasonable value of the treatment, particularly if there isn't a specific agreement on the front end regarding that price. And usually in these kind of situations, there isn't. Those of you who have gone to a hospital or a doctor, the unfortunate truth is you usually don't know how much the treatment is going to cost until you get that surprise bill in the mail. So regarding liens, they are usually subject to some kind of equitable reduction based on the amount of the settlement, because again, they attach to the settlement. So if there are lots of other liens or health insurance interests that are trying to seek reimbursement, that lien is then subject to that. On the other hand, a debt that isn't attached to the settlement and instead is just a debt that's attached to the person who needed medical treatment, it is often not subject to these equitable reduction arguments, although it's certainly an argument that can be made. So resolving hospital and provider liens, what is your usual approach? So usually we hear that there is some acceptance that the full billed charge is the actual amount that's due. And from there, most attorneys will ask for a discount or a reduction from that number. From our perspective, that full billed charge is a made-up number. It is a grossly exorbitant number that really shouldn't have any bearing to anything. But let's assume that the full billed charge is $50,679. You may have asked that the facility accept $35,000. This is for the initial visit, maybe there was a surgery that was involved, and you've settled the case for $500,000. So only paying $35,000 for the admission and the surgery maybe seems like a deal a little bit. Now the better approach is to find the reasonable value and negotiate upwards from there versus looking at the full billed charge and looking for a discount down from that number. Now, how do you find the reasonable value of care? It's complicated, but the cost of care can be found from the facility's hospital cost report, which is submitted to Medicare on an annual basis. Perhaps intentionally, this information is very hard to find and to synthesize and to actually get to the bottom of what that reasonable value is. But the information is out there. We have found that the reasonable value is often only 20 to 35% of the full bill on most of these hospital bills. So when you consider that you are seeking a 30% reduction from that full billed amount versus only paying 30 to 35% of the full billed amount, there's a big difference in between those two numbers. There's a lot of savings that can be staying with your client versus going to these hospital facilities. So let's take a look at the math of the better approach, assuming still that the full bill charge is $50,679. And if the normal reasonable value is 20 to 35% of that number, we're going to say that's $10,000 to $17,000. So compare that of a reimbursement to the hospital of $10,000 to $17,000 versus if you were seeking that 30% reduction or discount, where you asked for them to accept $35,000. Ultimately, with this better approach, you could be saving your client upward of $25,000. So I want to cover a couple results that we have obtained here in the last month or two here at Synergy. So this one is a Medicaid lien that was almost $500,000, and it went up and down multiple times during our handling because Medicaid was still paying for treatment and those bills were still being submitted. So that made the negotiations tricky, but ultimately after many passes, we were able to get the lien reduced as much as we possibly could, which was a savings of $400,000 or an 81% reduction. And it took some time. It took a lot of time because it was Medicaid, but our client, the attorney, and the injured party were standing right there with us, and they wanted us to continue battling and getting as big of a reduction as we possibly could. So for a $3.2 million settlement to only have to pay back $90,000 for that $500,000 lien, huge win. And as an example for a military lien with a settlement of $140,000, there was a lien asserted of $115,000, so a very large lien compared to the limited settlement. And we took a lot of time because these military liens always take a lot of time, but our team continued to push and push until we were able to obtain an acceptable reduction with a reimbursement of $20,000. So an 82% reduction of that $140,000 settlement, only $20,000 went back to this military lien. And finally, an example of a hospital lien that we recently handled. We obtained the cost of care for the treatment. The full bill charge was $83,000. And once we received that cost of care report, we saw that it was $16,000 was the reasonable amount. And we only offered that amount with no profit built in. That is sometimes what we end up doing is giving them some profit off of their actual cost of care to continue the negotiations and to entice them. In this situation, we nailed it the first time around with the facts of loss and all of the different issues that were present here, and they accepted that $16,000. So that was an 80% reduction off of that full bill charge, or only 20% of the full bill charge. So huge win on a $350,000 settlement and a $80,000 hospital lien to only have to pay back $16,000. So we have reached the end of the content of this webinar. Thank you for listening. Final word, if you are tired of dealing with the headache of lien resolution on your own, then Synergy is here for you. We are your ultimate lien resolution partner. We have hundreds of years of combined experience with our team of expert negotiators. We've got collaboration that takes place on a regular basis. We handle complex liens, simple liens, large liens, small liens, big settlements, little settlements. We can do it all for you. We've got these experts who come from the other side. They've got insider knowledge. We know how things work with those subrogation vendors and insurance companies. We've got people who used to be paralegals and work in law offices and know exactly what it is that you need to have done. So by partnering with Synergy today, you can gain access to this entire team of lien resolution specialists, and we will tirelessly work to get these liens reduced so that you can put more money in your client's pocket. We're on your side. Now is the time to make that smart move and partner with Synergy. So go ahead and give us a call, reach out to your Synergy contact, and we are on standby and waiting to help. Thank you for listening.
Hi, this is Jason Lazarus, Chief Executive Officer and founder of Synergy. Thank you for attending today's Synergy Insight presentation. Before we conclude, I wanted to take a moment to tell you a little bit about our team pictured on your screen right now. Synergy is a mission-focused organization dedicated to improving the lives of the injured as well as their families and helping trial lawyers focus on what they do best. We all care deeply about this mission. I am so proud of our incredible team that works tirelessly each day to get the best possible results for you and your clients. It's why Synergy has been consistently recognized as one of the fastest growing companies in the US. Contact us today to find out about forming a strategic partnership with Synergy that will transform your practice.